How the Better Business Act affects shareholder primacy. Hello, my name is Simran Katani, and today I'm going to be discussing whether shareholder primacy has changed under the new proposed Better Business Act, which is a piece of legislation proposed in 2021 to replace the Companies Act. So shareholder primacy remains a long-standing principle in company law. This doctrine allows shareholders to bear exclusive governance over companies, as they are the stakeholders who own the residual risk in case of insolvency. However, modern-day social governance has seen a greater emphasis on non-shareholder stakeholders. As environmental degradation and abuses for human rights by companies have become increasingly exposed, there have been calls for reform of the shareholder primacy doctrine. However, the existing legislation allows companies to still uphold shareholder primacy, with Section 172 of the Companies Act 2006 giving directors the legal duty to prioritise the doctrine. Thus, the Better Business Act campaign calls for reform of the system, proposing this act to legally oblige companies to consider other interests equally to those of shareholders. So firstly, the common law duty to promote the success of the company was codified under the Section 172 Companies Act. Firstly, the duty in 172(1) states that a director of a company must act in a way that he considers in good faith would be most likely to promote the success of a company for the benefit of its members as a whole. Thus, this section requires directors to proactively think about all the interests and take them into account in meetings. This is not just about ticking boxes, but rather giving proper consideration to the factors. However, abiding the duty is made easier by the lack of clarity in the section. The term have regard to does not place any weight on each of the individual factors. Instead, this term is only to the extent the factors affect the members or the shareholders. Thus, case law post-2006 suggests that it has become a tick box, with evidence of compliance simply just being noted in the board minutes rather than in reality. So the BBA campaign, led by BLab UK, has a coalition of over 650 businesses and organisations. Overall, the campaign aims to amend this legislation of Section 172 to replace the doctrine of shareholder primacy. So the proposal is as follows. Section 172 would be replaced as: a director of a company must act in the way the director considers in good faith would be most likely to advance the purpose of the company, and in doing so must have regard to the following considerations. So, the new legislation is replaced by the definition of the word purpose of the company. And this purpose is stated in 172 subsection 2 as benefiting its members as a whole, whilst operating in a manner that also benefits wider society and the environment in a manner commensurate with the size of the company and the nature of its operations, and reduces harm the company creates or costs it imposes on wider society or the environment, with the goal of eliminating any such harms or costs. Therefore, instead of directors prioritising shareholders' interests above other interests, the duty makes shareholder interests equal to the interests of wider society. So how will this affect the way the directors operate? Well, under Section 172's duty to promote the success of the company, the UK government has defined success as the long-term increase in value. Therefore, it's almost impossible under Section 172 for directors to consider other interests whilst they have a statutory duty to prioritise financial returns. The BBA, the Better Business Act, will change this. Instead of directors considering long-term success of the business, which can be financial or profitable success, the new duty to advance the purpose of the company would be to consider equally the impact of the firm on the society and the environment. This creates a triple bottom line. Directors are given the power to take more factors into consideration when making decisions: shareholders, the environment, and wider society. However, in reality, will this change how directors operate? Well, Section 172 already gives directors the freedom to pursue purpose, as purpose is gained through creating value for stakeholders via the shareholders. Nevertheless, for as long as there are no quantifiable guidelines on the weight directors must attribute to wider society and the environment, directors will be able to continue acting almost solely in the best interest of the members. This is because it is still only the shareholders who can make a claim on behalf of the company. Thus, directors are only legally accountable to shareholders. To avoid a claim, directors would naturally place as minimal weight as possible on the other factors to appease shareholders. This will not change unless there are either legal requirements to prioritise other interests over shareholders, or until stakeholders can also bring a claim against directors. The former is more practical than the latter, given that nobody would become a director if they were open to legal claims from anyone. So how will the BBA affect the shareholders? Well, the BBA is unlikely to affect shareholders significantly and overall will have neither a negative or a positive impact. This is because the Act does not create new rights for non-shareholder stakeholders. Other groups have no way of holding directors to account. The duty continues to be held to the company, so only the company can claim that a director has breached their duty. The company is the shareholders, and therefore it's the shareholders who are holding directors accountable. If the directors do not consider all the BBA requirements and instead maintain shareholder primacy, it is the duty of the shareholders to call them out for this. It would not be in their favour to do so. The alternative would be to allow non-shareholder stakeholders to claim that a director has breached their duty. However, this might discourage directors from the board, as it will open up the gates to a potentially unlimited number of claimants. Regardless, for as long as shareholders have sole voting rights for directors, their interests will inevitably retain primacy, as they alone wield elective power. What might change are the aims and the values of the shareholders. The Friedman Doctrine recognises that it's not businesses who are carrying out a specific social responsibility on behalf of the business itself. It is the executives and directors who choose to value social issues alongside their duties to the company. Today, the same can be seen in shareholders who invest in and steer companies to drive for social change. Rather than priority going to shareholder returns, the focus is on shareholder welfare and satisfaction, not just in pecuniary rewards. Thus here, the BBA may have a residual positive impact for shareholders. Although the Act is maybe legally weak in achieving its aims, it encourages and leads shareholders to value non-financial gain and steer investment into companies that are doing more to preserve society. It formally creates idealistic norms, which shareholders are increasingly obliged to consider in their investment practices. Thus, the BBA may fail to achieve its practical aims, but it may have a significant behavioural impact on decision makers. Despite the changes not being legally enforceable, the Act encourages inherent social change and higher standards of societal responsibilities. Unlike existing legislation, which arguably just lists wider societal considerations, the BBA explicitly changes the default legal position of the overall legal objective being long-term profits. Under the BBA, directors do not have to prioritise shareholders. Directors must consider external interests equally to shareholders' interests. This is a prominent step towards a deconstruction of profit maximisation goals and the prioritisation of societal needs. So the BBA ultimately creates a precedent in the direction of change and actual balance, unlike the existing Section 172, which does list to more than codify the existing common law of shareholder primacy. Thank you for listening today.